I'll tell him. Just send an email. I'll circulate.
My lords, may I mention a matter which is listed today before my lords? My lords, actually,
Wait for the matter to be
lords,
called out. Wait for the matter to be called out. Yes.
like,
No, my lords, we have filed, my lords, the status report, which we have circulated yesterday. And then, my lords, we've also filed the report of the State Health Department. My lords, they've not gone back to work, the doctors, my lords. 23 people have died in the process.
Now, what about the CBI? Has the CBI?
Lord, my report is ready, my lord.
We saw your status reports, which were.
My lords, we filed a separate application, my lords, which
Lord,
I think has.
I don't think I have the copy. I'm not complaining. I'm just requesting him, my lord, to give it to me right now. Maybe they have served, it has not reached me, or they have not served, whatever. my lord.
It's not served. It's not served.
Not served, my lord. They have not served on me.
Yes.
Sealed on.
Put it in a sealed envelope and therefore we.
Sir, sorry.
Okay. These for the parents. One thing, my lord, what is filed by Mr. Sibal is not served upon me. That's what he said.
It is not filed. It's not filed. It's only given to the
But if
court.
they want to say something, why hide something from the CBI?
Well, like,
You've
let's
already
see
done
what
many
the-
things.
I mean, I think let's not get lost in.
Yes, Madam.
Yes,
Let's see what this. Let's see the. First and foremost, let us find out what the status of the investigation is.
Yes.
So can you?
Not even with them.
residence of the, Mr. Solicitor, what is the distance between the residence of the principal of the Arbitrator Medical College and the medical college?
15 to 20 minutes it takes, maximum.
It's near to the more than 6.
We have answered the question whether an application for anticipatory bail under section 438 of the Code of Criminal Procedure, 1973, is maintainable at the instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 39 of Gurbakh Singh CBA. 2. There is no express or implied restriction in the CRPC in any other statute or in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense, while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with the previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent offense is obtained by the accused, it shall no longer be open to the investigating agency to seek remand of the accused in relation to the subsequent offense. Similarly, if an order of police remand is passed before the accused is able to obtain anticipatory bail, it would thereafter not be open to the accused to seek anticipatory bail, and the only option available to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India, with the aid of the provision of anticipatory bail, as enshrined under Section 438 of the CRPC, cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, the same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. We have also explained why Narinderjit Singh Sahni should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits.
Beautifully read. Thank you.
You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator.
Finally,
Fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned.
Can be fair.
Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I may, if I can mention, my lords, there's a matter for which we've sent an email. We have also gone between 10 and 10:30, as the lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of, dismissing the quashings. We are a little concerned.
Yes, all other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the
Except for these are matters before your lordships, after notice matters. Lords, concerning the university which your lordships have been hearing in part. Lords. Sorry, my lords. My lords, it was last listed before your lordships bench, my lords, on 13th of...
First. Therefore, my lord, I am taking it in that spirit. Please have a look at, my lord, this left-hand side and the right-hand side, my lord. Kindly go through it, my lord, with some, my lord, degree of attention. Your lordships, I have gone through, my lord.
Certificate, yeah. Yeah.
Entry is on 250.
उसमें कुछ होगा था.
May I answer? Well, the death certificate was given at 1:47 p.m. Malats, and the UD entry was at 2:55 at the police station. 2:55.
That is 861.
That's right. There's the second question, Your Lordships. Subsequent proceedings, whether the inquest report or the CJM's order and all other documents.
What is the GD entry by virtue of which 861 of 2024 comes into existence?
565.
65.
Yes. DD entry 565.
And what time is GD entry 565 recorded?
At night, Malad. Oh, 2:55 p.m. Malad. 565, 2:55 p.m. I can hand it over.
So GD 565
At 2:55 p.m.
is recorded at 2:55.
Yes.
GD was
Yes, it's there.
2330.
This is
But
a certified copy, Malad.
565 is merely a medical
This
certificate.
is a certified copy, Malad.
Page 64.
Not a medical.
Extract
I
from
have
the
the copy of
Tala
GD
Police
entry,
Station daily register. It's not a
2330.
medical entry.
Look at 11:30 night. I have the copy.
No, I have a copy too.
Certified.
If certified copy, we've just given it to the court.
So he is still this. He's still this. Should be
The inquest, Malad.
What is the time?
Yeah, give yours.
420.
Just make sure, let's not.
Judicial magistrate.
420 to 440.
The judicial magistrate arrives and conducts it.
And the judicial magistrate arrives and conducts it. He comes at 410 And then the inquest is conducted at 4:20 to 4:40.
Inquest is videograph. So this
And the it is videographed.
yes, and the same has been saved on a card which we can.
Sybil, also, second question, when was the search and seizure actually carried out?
Just minutes, just. 8:30 to 10:45.
8?
8:30 to 10:45. The photographs had been taken before, Malaj.
8:30 in the morning or in the evening?
Evening, Malaj.
The body was found in the morning at 9:30.
That's right.
It cannot be
Photographs were
before that.
taken.
It's only when the water is removed.
Once the body was removed, Malaj, for post-mortem, then only, Malaj.
And by whom? There is some relevance. Therefore, my lord, I would like my learned friend to ask. There is some relevance.
Malaj, we have photographs from 12:45 p.m. onwards of everything that happened. We have the original with us.
During the course of the previous hearings, and therefore I think though the investigation is going on, we can share this because you've all said it openly,
Yes, Malaj.
that there is